family support, child custody, and parentage. Air Force. Air Force Instruction, FE 36-2906. Personal financial responsibility. Navy. Navy Military Personnel Manual Milpersman Art. 1-754 30 Support of Family Members Art. 5-800 Paternity Complaints. Marine Corps. Marine Corps Order P5-8-16 Vol. 9. Marine Corps Legal Support and Administration Manual Legal Admin. Dependent Support and Paternity. Coast Guard. U.S. Coast Guard Commandant Instruction. Contingent M11602 Discipline and Conduct. Chapter 2E Support of Dependents. In addition to service regulations, military units will often issue their own regulations, as will installation or garrison commanders. These local regulations are usually found on installation or unit websites, and may supplement existing service regulations or may cover areas not addressed in other regulations or directives. Finally, each of the services supplements its regulations with policy memoranda that address very specific areas of administration or conduct not covered in other regulations or directives. Military resources. In addition to the commander, there are military resources that can assist a child support caseworker or attorney. Many of the resources are service-specific, and others are available across DOT. Installation Command Legal Offices. Virtually all military installations have legal staff assigned to them, which may consist of military lawyers, civilian lawyers employed by the military, or both. Installation legal offices may be called an Office of the Staff Judge Advocate, a Legal Assistance Office, or commonly, the JAG Office Judge Advocate General. The lawyers and legal support staff at an installation legal office primarily serve the commanders, their staff, and military members and their families. Therefore, the spouse of a service member can request assistance just as the member can. The Legal Assistance Office is usually where a military member will go with questions about paternity and child support. Military legal assistance offices can also assist service members in developing family care plans and provide information about resources related to mediation of parenting time issues. Military lawyers do not represent service members in civil support or custody proceedings. However, they can provide members with general information about child support and custody laws. It is very helpful if child support attorneys establish a relationship with the Installation Legal Assistance Office. This can be accomplished through personal meetings and speakers programs. Such interaction will help ensure the military lawyer provides correct information about the child support program and help the child support attorney learn more about military procedures. It will also result in improved communication and cooperation between the Child Support Agency and the Legal Assistance Office. Family Life Centers. Larger installations will often have Family Life Centers family advocacy programs that are designed to improve the quality of life for military members and their families. If the Child Support Agency wants to distribute literature or offer a program to inform parents about paternity establishment and child support obligations, the Family Life Center is a valuable place to contact. Additionally, these programs may be able to assist custodial parents in understanding the wide variety of benefits to which a dependent child of a military member may be entitled. Identification card facilities. Military identification card facilities are located at all large installations. These facilities can provide important information about how a parent obtains a next-generation uniformed services identification card for a child, as well as how to enroll the dependent in the Defense Enrollment Eligibility Reporting System DEERS. Enrollment in DEERS is required prior to the issuance of an identification card and is also tied to eligibility for medical care under the military health program called TRICARE. See full discussion of DEERS later in the chapter. Internet sites. The military provides the greatest amount of information about itself on the Internet. Virtually every publicly releasable military address, phone number, acronym, regulation, and policy is available through the Internet. The greatest drawbacks, of course, are that information can become outdated quickly, and there is so much available that it can become difficult to navigate and pinpoint the exact information you are seeking. There are sites for DOD and each of its component agencies, each of the military departments and service branches, the reserve components, and almost every installation, base, camp, station, or fort in the world. See Exhibit 14.1. A key to successfully navigating the internet as you search for the answers to your questions is to narrow your search to the lowest applicable level. This means you must determine if your issue is local. Does Fort Bragg have a legal assistance office? Service specific. What is the Air Force policy on paternity establishment? Or agency specific to what Defense Finance and Accounting Service DFAS address? Does one send a withholding order? Most military internet sites are user-friendly, have search functions, and provide links to other sites. Location. Title Roman 4D Locate Resources. It is important to remember that all Roman 4D locate resources available to the Child Support Office in civilian cases are also available in cases involving the military. If a custodial parent is unsure whether the non-custodial parent is in the military, a caseworker or attorney may use the public website that the Defense Manpower Data Center (DMDC) has established to learn the current active military status of the individual. The site requires the creation of an account, and use is restricted to financial institutions and others with financial and legal transactions with eligible service members for the sole purpose of ensuring that those service members receive Service Members Civil Relief Act SCRA protections in accordance with 50 U.S.C. Chapter 50. The site will ask for the person's name, either the person's Social Security number SSN or date of birth, and the date on which the restricted user is requesting active duty status. Based on that identifying information, the website will provide a status report. The report will indicate the person's active duty status on the date requested, referred to as the active duty status date. If applicable, the report will also provide the person's active duty start date, active duty end date, and service branch. It will not, however, provide the residential or duty address of the service member. Federal Parent Locator Service. The Federal Parent Locator Service (FPLS) is arguably the most important Roman 4D locate tool in military cases. If a custodial parent does not know the non-custodial parent's SSN, a caseworker or attorney may use the FPLS to learn the number, provided they are able to give sufficient identifying demographic information. Additionally, the FPLS matches with several external federal agencies, including the Social Security Administration, the Internal Revenue Service, the Department of Defense, the National Security Agency, the Federal Bureau of Investigation, and the Department of Veterans Affairs (VA). The FPLS sends state locate requests to the external locate sources at least weekly, depending on the locate source. Responses are sent to the state as they are received from the external sources. The National Directory of New Hires (NDNH) and the Federal Case Registry (FCR) are the central parts of the FPLS. The NDNH receives information from state directories of new hires and state workforce agencies. The FCR receives information from state case registries. States send information as often as daily to the FCR, but at a minimum weekly. There are daily matches between the NDNH and FCR, and responses are returned to the states within 2 days. However, because of the timeframes employers and states have for making reports, it may be as long as a month after a person is hired that the NDNH receives the information and can send the state a response from NDNH matching. There are 2 NDNH records that are particularly useful for locating service members and identifying their military income. The NDNH New Hire NH record provides address information for newly hired military personnel, and the NDNH Quarterly Wage QW record provides address and wage information for active duty military members and retirees. Retirees and reservists called back to duty are reported in QW, not NH. In addition, both records include the DOD agency status indicator with the following options: A active duty employee, C civilian employee, P pension or retired employee QW only, R reserve employee. Additionally, the FPLS can return information from DOD when a child support agency submits a locate request for DOD data. The matrix below identifies the .locate information about various military populations that is returned to states. The .locate response provides the following helpful data elements. Finally, the FPLS can return information from the VA when a child support agency submits a locate request for VA data. The VA locate response provides the following helpful data elements. OX Child Support Portal. In 2010, OX implemented the Child Support Portal, which provides an alternative way for child support staff to request FPLS information. Locate requests submitted through a state system will result in responses sent to the state system. The portal is a secured internet application that allows staff to submit a locate request outside of their state process to locate sources they select. Requests submitted through the portal will result in responses sent to the portal. A state may elect to have a copy of these responses also sent to their state system. The portal locate application provides child support staff with direct access to the following FPLS locate sources: National Directory of New Hires, Department of Defense, Federal Bureau of Investigation, Internal Revenue Service, Social Security Administration, Department of Veterans Affairs. The state administrator determines what type of locate access is available to an agency caseworker or attorney. NDNH data is available immediately through the portal. Responses from external agencies are returned in a week or less. In addition, the portal entitlement application allows an authorized person to request base pay, bonus pay, and other entitlement, both taxable and non-taxable, for a non-custodial parent NCP, putative father PF, or custodial parent CP in an open Roman 4D case. The following is a sample of the entitlement response report, including examples of all possible categories of compensation. Military locate resources. In addition to Title Roman 4D locate resources, there are military locate resources that exist on the local and national levels. For the best results, use the military member's full name and SSN. Due to the nature of military service, the residence address and duty station for service members frequently change. In addition, there are instances when the military is prohibited by national security from disclosing the residence or work address for a given member. As all branches of the military review their address disclosure procedures, it is becoming more difficult to obtain address information from the military. Local military locate resources. Local military resources provide locate information that is more limited than national military resources. However, if the child support agency can narrow the location of the service member to a particular installation, the local military resource may be the quickest. The best local military locate resource is the military installation. An installation often maintains a central locator office to keep track of the individuals assigned to that installation. The telephone number for an installation's locator office is available through the installation's information operator. In order to obtain the individual's military unit address, you must have that person's full name and SSN. The individual's military unit address is important because it allows you to contact the individual, and if the member fails to cooperate, their commanding officers. The military's legal assistance offices are another local locate resource. Most large military bases maintain legal assistance offices. Their duties include assisting spouses and dependent children in obtaining the military service member's military address. See previous discussion, Installation Command Legal Offices. National Military Locate Resources. Each service maintains a locator service that will provide immediate family members and government officials, such as a child support agency, with location information free of charge. See Exhibit 14.2. However, the extent of information is different for each service. For example, the Army Data Center will only locate individuals on active duty, while the Air Force will assist in locating active duty individuals, reservists, National Guard, and retirees. For active duty members, the address information that the military locator services provide is the member's unit address, which may include an APO Air Army Post Office or FPO Fleet Post Office designation if the member is overseas. To determine the actual geographic location of an IPO or FPO address, contact the U.S. Postal Service or the Postal Office at the nearest military installation. In order to process a request, the Military Locator Service needs the service member's full name and SSN. The member's date of birth, rank, and location and time period of the member's last duty station is also helpful. In deciding when to contact a military locator service, keep in mind that military records may run up to 90 days behind reassignments, and most military moves occur in the summer. Usually, members' military addresses are more useful than their home addresses. While members may be away from their home address for several months at a time, they are rarely away from their military address for more than 2 weeks at a time. In addition, by concentrating efforts on the military address, you are in a better position to request help from an individual's chain of command. If, however, you need the service member's home address, direct your request to the installation personnel officer for the member's duty station. In especially difficult cases where the home address is needed, but the military will not provide it, you may need to use the Freedom of Information Act (FOIA). Direct the FOIA request for a service member's home address to the General Counsel for the appropriate branch of the military. See Exhibit 14.3. If the Child Support Agency needs to locate a service member who is incarcerated in a military confinement facility, the agency representative can contact the legal office or military police of the member's last duty station. It is helpful to provide an approximate date of the member's conviction. Personal jurisdiction. In order to establish parentage, establish a support order, or modify a support order, the tribunal must have personal jurisdiction over the respondent. A service member is subject to the personal jurisdiction of the state in which he or she physically resides or has declared as his or her legal domicile. Therefore, if the non-custodial parent service member is temporarily overseas, the child support attorney can file a petition for child support in the service member's state of residence or domicile. A member's residence or legal domicile is not necessarily the same as the member's home of record. The home of record is the state from which the member entered the service. The primary purpose of the home of record is to determine military benefits, such as travel entitlements upon separation from the military. It may or may not be the same as the member's state of legal residence or domicile. How does an attorney decide a service member's state of legal residence or domicile? It will depend upon the facts and circumstances, but one of the best sources of information is the member's leave and earnings statement (LES). One of the fields on the LES is the member's home for income tax withholding purposes. The long-arm bases of jurisdiction apply to a non-resident service member, just as they do to civilians. Keep in mind, however, that in addition to contacts with the forum, there must be proper service on the service member. Service of process. As discussed in earlier chapters, an important element of personal jurisdiction is service of process. Service of process is the delivery of a legal document to an individual, notifying the person of a claim or charge against the person, or informing the individual of specific acts that he or she is required to perform, such as appearing before a tribunal. Service on a member who is off base. Although many military members may live on an installation, the vast majority live in the neighboring communities surrounding the installation. These members can be treated as any other person subject to a state's service of process procedures and jurisdictional requirements. Methods for service of process include mail, voluntary acceptance of service, and personal service by a civilian authority depending upon the type of action that is being brought. For example, under most state laws, establishment of an initial support obligation requires voluntary acceptance of service or personal service by an authorized official. Service on a member who is on base. If a military member resides on a military installation, you can still serve the member with process. However, there are some limitations that will apply. Service by mail. Many enforcement actions do not require personal service. If service by mail is acceptable under the forum state's law, you can send a first-class letter or a certified or registered letter with return receipt requested depending on what the law requires to the obligor's military address. Military facilities and naval craft have post offices, so even return receipt requested service is available. Personal service. If the remedy requires personal service, such as with an establishment or a contempt action, service may be more difficult. Military authorities are not responsible for serving process on members of the armed forces. Neither the Judge Advocate General's JAG office nor the Installation Command can force a member to accept services. Sometimes they can facilitate service, as will be discussed later. If the service member must be served formally on military property, federal law and military regulations will determine whether the process server may gain access to the installation. The nature of federal jurisdiction over military installations in the United States varies. Sometimes federal jurisdiction may be so exclusive that a state agency cannot serve process on the installation. In such cases, military commanders will determine where the member will accept service. If the member refuses to do so, the commander may deny the process server access to the installation. In most cases, however, states reserve the right to serve civil and criminal process. This is true on military installations where there is concurrent or partial federal legislative jurisdiction. It is also true on military installations where the federal government just has a proprietary interest in the land or buildings. If the military installation is under concurrent or proprietary jurisdiction, the state has the right to serve process on the installation according to state laws. A sheriff or other proper civilian official may therefore enter the installation, contact the local military police MP, identify the person to be served, and attempt service. The installation's central point of contact for service of process will facilitate service using the procedure put in place by the installation or garrison commander. For example, some installations arrange for the member to appear at the MP station to accept service. If there is no established procedure, it is useful for the child support attorney to meet with the command, JAG or Legal Assistance Office, and military police to develop such a policy. It is in their interest to establish a service of process liaison so that disruption of military activities is minimal. The attorney can also point out military policy that requires a member to support his or her dependents. The member should not be allowed to use his or her location on base as a way to evade service and avoid family support obligations. The best way to determine an installation's type of jurisdiction is to call the Installation Legal Office. The Installation Legal Office can also explain policies and regulations governing service of process on the installation. Service of process on an installation is often centralized to control and monitor the presence of civilian law enforcement or other civilian authorities, as well as to provide for an orderly procedure that will have the least impact on the installation and its mission. The Installation Provost Marshal or Law Enforcement Section is the usual conduit. In addition to an installation's policies and regulations, the service branches are subject to federal regulation. On installations where the state has reserved the right to serve civil process, Army regulations require that commanders first determine where the member wishes to accept service. If the member declines, the requesting party is allowed to serve the process in accordance with applicable state law, subject to reasonable restrictions imposed by the commander. In order to protect against interference with mission accomplishment and to preserve good order, Navy and Marine Corps regulations provide that service cannot be made without the commander's consent. Where practical, the commanding officer of a naval installation will require that the process be served in his or her presence or in the presence of a designated officer. If the process server is from a state court in the jurisdiction where the naval station is located, regulations provide that the command ordinarily should not prevent service of process, as long as delivery is made in accordance with reasonable command regulations. Commanders may designate an appropriate location where the process server and the member can meet privately, and may order the member to that location. The procedures are different if the military installation and the court that issues the process are located in different states. In such cases, military policy does not require the member to accept service. If the service member refuses to accept service, military authorities may notify the process server of the refusal and deny access to the installation. If a child support attorney experiences problems with service of process on a military installation that cannot be resolved with the base military police, the attorney should call the Legal Assistance Office for the installation involved. Establishing and maintaining a good relationship with the installation legal office will help you greatly in carrying out your duties. Remember, military authorities with questions concerning service of process will ask the installation legal office or their legal advisor about what is permissible and what is not. Military members will also often seek legal help from the installation legal assistance office. If a legal assistance attorney contacts you on behalf of a military member about your state's laws regarding service of process or child support, inform the attorney of the possible consequences for delays in establishing or enforcing an order, such as an award of retroactive support or the accrual of an arrearage. As a last resort, if it appears that command is supporting a member's evasion of service, it may be necessary to contact the installation's Inspector General. Service on a member who is overseas. Serving process on military members stationed at overseas locations or on a ship can be a bit more difficult compared to service at United States locations. It is important to remember, though, that the same general rules concerning service of process apply. Service by mail. Just as with United States installations, service of process by mail, if permitted by both the forum state and the jurisdiction where the military member is located, is an easy and efficient method of service. Military postal clerks follow the same guidelines as the United States Postal Service. Although the address may be an Army or Air Force Post Office APO or Fleet Post Office FPO, it is still U.S. mail, and again, certified mail and return receipt requested services are available. Some countries where military members are deployed do not permit service of process by mail. You should check the State Department's website to determine whether service by mail is permitted in the country where you intend to serve the military member. If the child support agency attempts service by mail but does not receive a return receipt, prepare a second set of documents and place them in an envelope addressed to the military member, with the return receipt affixed and postage paid. Place this envelope into a larger one and address the outside envelope to the military postal officer for the APO or FPO where the military member is located. Include a memo to the postal official that details your previous efforts to obtain a return receipt. In compliance with military policy, ask that the military post office MPO personnel obtain the member's signature prior to delivering the envelope to the member and send the return receipt back to you. If the member refuses to accept the certified or registered mail, ask that the MPO personnel endorse the document refused and return it to you. As long as you have the receipt or label number for the certified mail you sent, you can go to the United States Postal Service website to track the status of the package or envelope. Voluntary acceptance of service. If the forum state's law requires personal service, you can attempt to contact the military member or the commanding officer and request the voluntary acceptance of service. This is often a useful first step. The consequences of failing to abide by a support order, which could lead to an order to show cause for contempt, can have much greater consequences to a military member stationed overseas. That is especially true if the military member is required to return to the United States in order to attend civil proceedings. The Hague Convention on the International Recovery of Child Support and Other Forms of Family Maintenance. In 2007, negotiations were completed on the Hague Convention on the International Recovery of Child Support and Other Forms of Family Maintenance Hague Child Support Convention. More than 65 countries participated in the negotiations, including the United States. The convention became effective in the United States on January 1, 2017. As of February 1, 2021, the convention is in force between the United States and 38 countries. The Hague Child Support Convention details assistance that central authorities are required to provide with regard to applications for support. Among those responsibilities is the requirement to take all appropriate measures to facilitate service of documents. Pursuant to Article 50, The Hague Child Support Convention does not affect the Hague Convention of 15 November 1965 on the service abroad of judicial and extrajudicial documents in civil or commercial matters. See subsequent discussion. Bilateral arrangements with foreign reciprocating countries. In 1996, federal legislation authorized the Department of State and the Department of Health and Human Services to establish and administer reciprocal child support agreements with other countries. The countries with which the United States has entered into bilateral arrangements are called Foreign Reciprocating Countries (FRCS). As of February 1, 2021, the United States has bilateral child support arrangements with all but one of the Canadian provinces and territories, and with 4 countries that are not also Hague Child Support Convention countries: Australia, El Salvador, Israel, and Switzerland. An attorney who is having difficulty with service of process in an FRC may be able to seek assistance from the central authority in that country. Each FRC must designate a central authority to facilitate the processing of child support cases involving its residents and residents of the United States. OX has developed numerous caseworkers' guides for specific FRCS that provide more information. The Hague Convention on Service Abroad. The 1965 Hague Convention on Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters Hague Service Convention streamlines methods of serving documents originating in one country that is a party to the Convention upon persons residing in another country that is also a party to the Convention. The United States is a party to this convention. The Hague Conference website provides complete details on the contracting countries to this convention, as well as the methods of service available in each of those countries. Service of process under the Hague Service Convention is relatively easy and less expensive than some other methods of service abroad. You send your request for service of process to a country's designated central authority, which is usually the Ministry of Justice. The names and addresses of the central authorities for all member countries are listed in the convention. The request for service is sent using a request for service form, which you can fill out online. The completed form and underlying documents to be served, with accompanying translations, if applicable, should be mailed by any competent authority or judicial officer directly to the foreign central authority. The court or the child support attorney should execute the portion of the form marked Identity and Address of the applicant and the Name and Address of the requesting authority. Reference to the authority for the request must be included in the request. State that the request is made pursuant to Rule 4C2A, United States Federal Rules of Civil Procedure, and any other pertinent federal or state law. Unless requested otherwise, the central authority itself or its designee will serve process according to its country's laws governing the service of process upon persons within the country's jurisdiction. If personal service is required, the form must so note. Generally, there are no fees for service of process through the central authority. A central authority may bill costs of personal service in a remote location. On the reverse side of the request for service form, there is a certificate of service form that the central authority will return to the requesting party once service is completed. It is important to remember that a central authority may not always be able to serve process on members of the U.S. military stationed in that country. Issues that may prevent service include a status of forces agreement SOFA between the United States and the host country, Inter-American Convention on Letters Rogatory and Additional Protocol. During the 1970s, countries that were members of the Organization of American States (OAS) entered into a pair of international agreements collectively called the Inter-American Convention on Letters Rogatory and Additional Protocol. Similar to the Hague Service Convention, these are in force with 17 Central and South American countries. The United States has ratified it, noting a reservation only to Article 2B that pertains to evidence. The process for service is similar to the Hague Service Convention, with slight changes made in the forms used and the requirements for certifications by a clerk of court. Another difference is that, unlike the Hague Service Convention, the Inter-American Convention requires that all service requests come from the requesting country's central authority. The central authority in the United States for the Inter-American Convention is the Office of International Judicial Assistance OIJA within the U.S. Department of Justice. For that reason, outbound service requests under the Inter-American Convention must come from OIJA by way of its contractor ABC Legal. ABC Legal charges no fee to send service requests pursuant to the Inter-American Convention. U.S. litigants, however, must complete and submit to ABC Legal all required forms and obtain the official seal of the U.S. Domestic Court. Personal service by a foreign agent. This method of service is usually expensive. It is imperative that you verify with the State Department's Office of Citizens Consular Affairs or an attorney in the foreign country that you are complying with the country's current law. You may be able to seek assistance with personal service if the State Department and the Department of Health and Human Services have declared the country to be a foreign reciprocating country or political subdivision of a country, or if your state, as the initiating state, has a reciprocal support agreement with that country. In most states, the Attorney General's office is the place to contact to determine with which countries the state has an agreement. Letters rogatory. Letters rogatory are requests from a court in the United States to a court in a foreign country seeking assistance in obtaining evidence or in effecting service of process. Letters rogatory are particularly used in countries where no other method of service is available. Preparing letters rogatory can be a time-consuming, complicated, and frustrating process. Unless no alternative exists, letters rogatory should be your last resort. Service on a member who is on board a ship. For military members who are aboard a ship outside U.S. waters, the best method for service of process is through the mail if the forum state's law permits this method. Even military members on a ship will have an APO Army or Air Force Post Office or FPO Fleet Post Office address in the United States. If you attempted service by mail but did not receive a return receipt, follow the procedures noted earlier to seek assistance in obtaining a return receipt. Explain to the officer in charge of the service member's military post office that you never received a return receipt when you mailed the first notice, so you request that proper mailing procedures be followed this time, and that you receive a receipt upon the delivery of the enclosed letter to the service member. Naval regulations provide that if the member refuses service by mail, the refusal will be noted and the documents returned to the sender. If personal service is required by the forum state's law, you can attempt voluntary acceptance of service by the military member. Again, it may be useful to send the member's commanding officer a letter requesting the commander's assistance in service of process. The commander cannot serve the member with process. However, you can ask the commander to explain the consequences if the service member fails to respond to a child support action. It is more difficult to personally serve the military member when the ship is in port. In times of military alert, the military is unlikely to disclose information about where a ship will dock during voyage. It may be necessary to delay service of process until the ship returns to its home port, whether that location is stateside or overseas. Service on a member who is in combat. Problems that arise in attempting to serve process on military members can be compounded when the military member is involved in a contingency or combat operation. Military members may be away from their normal stateside or overseas installation for months, and even years, when they are involved in any manner of deployment. These temporary duty locations may not be able to be disclosed or may constantly change within a particular operation. If you are trying to establish an order, you may be better off asking the military to enforce its own support regulations as an interim measure until the member's deployment is over. Service Members Civil Relief Act. Scope. The Soldiers and Sailors Civil Relief Act (SACRA) was originally enacted in 1918, reenacted in 1940, and updated in 2003 with the enactment of the Service Members Civil Relief Act (SCRA). Since 2003, the SCRA has been amended several times. It was recodified in 2015 and is now found at 50 U.S.C. 391-4043. It is not found in state statutes. The primary purpose of the SCRA is to postpone, suspend, terminate, or reduce the amount of certain civil obligations, so that members of the armed forces and certain other individuals can focus their full attention on their military or processional responsibilities without adverse consequences for themselves or their families. The SCRA is not intended to be an answer to all legal problems encountered by a military member. The SCRA provides this purpose statement that serves as a guide to the courts and administrative tribunals in interpreting the intent of the Act. The purposes of this Act are: 1. To provide for, strengthen, and expedite the national defense through protection extended by this Act to service members of the United States, to enable such persons to devote their entire energy to the defense needs of the nation, and 2. To provide for the temporary suspension of judicial and administrative proceedings and transactions that may adversely affect the civil rights of service members during their military service. It is important to understand that the SCRA is not a shield that exempts military members from the judicial or administrative process. It is a provision for the suspension of certain civil proceedings during times that a military member's service affects his or her civil rights. The SCRA protects all service members on federal active duty, including members of the U.S. Armed Forces, Army, Navy, Air Force, Marine Corps, and Coast Guard who are on active duty service, or who are absent from duty as a result of being wounded or being granted leave. Reserve, National Guard, and Air Guard personnel who have been activated and are on federal active duty. National Guard personnel under a call or order to active duty for more than 30 consecutive days under Section 502F of Title 32, United States Code, for purposes of responding to a national emergency declared by the President and supported by federal funds, and commissioned officers of the Public Health Service and National Oceanic and Atmospheric Administration in active military service. Actual deployment, while in active military service, is not a prerequisite to qualify for the protections of the SCRA. The SCRA does not apply to DoD civilians, contract employees, or military retirees, and most of its provisions do not apply to military dependents directly. As originally enacted, the SCRA only applied to judicial proceedings. Under the SCRA, these protections now also cover administrative procedures, such as the Administrative Child Support Enforcement remedies, mandated under the Personal Responsibility and Work Opportunity Reconciliation Act of 1996. Exhibit 14.4 summarizes the provisions of the SCRA. Start and termination of protections. The SCRA's protections begin no later than when a person enters active military service. However, certain provisions expand this coverage. For example, reservists are entitled to most of the Act's rights and protections on the date they receive active duty orders. A service member is also protected during any period in which the member is absent from duty, if the absence is due to sickness, wounds, leave, or other lawful cause. The SCRA's coverage usually terminates on the date on which the service member is released from military service or dies while in military service. Other sections of the Act qualify this period of military service. For example, the SCRA protection calling for the stay of a civil proceeding extends for 90 days after termination of or release from military service. Similarly, an application to set aside a default judgment must be filed no later than 90 days after the date of termination of or release from military service. Stay of civil proceedings. A stay means that proceedings are put on hold for a certain time period. The stay provisions of the SCRA apply to both judicial and administrative hearings and proceedings. A request for a stay of proceedings may be made at any point of the proceeding, provided it is made during the service member's service or within 90 days after the member's termination of or release from military service. In determining whether a service member is entitled to a stay under the SCRA, the court or administrative tribunal must ask two questions. First, is the service member in active military service? As noted, to be eligible for a stay under the SCRA, a service member must be in military service, or it must be within 90 days after the member's termination of or release from military service. Second, in support of the motion for a stay, did the member provide the required documents to the court or agency? If the member makes an application for a stay and presents the required documents, see discussion herein. The court or administrative tribunal must stay the action for a period not less than 90 days. Any stay under 50 U.S.C. 89-32b applies to proceedings filed during the member's military service, even if they relate to obligations that arose before the member joined the service. For example, it would apply to a paternity proceeding that was initiated during the member's service for a child conceived prior to the member's entry into military service. Procedural requirements. The SCRA requires that the service member provide a letter or other communication setting forth facts, stating the manner in which the member's current military duties materially affect the service member's ability to appear, and stating a date when the service member will be available to appear. The service member must also provide a letter or other communication from the service member's commanding officer, stating that the member's current military duties prevent the member's appearance, and that military leave is not authorized for the service member at the time of the letter. Instruction 1D327-6. The fact that a service member is on active duty does not automatically mean that the member's current military duties materially affect his or her ability to appear in a civil proceeding. Instruction 1D327-6 Jan. 15, 2021 states, the Levin Court determination and/or child support leave. When a service member requests leave on the basis of need to attend hearings to determine paternity or to determine an obligation to provide child support, ordinary leave shall be granted unless the member is serving in or with a unit deployed in a contingency operation, or b. exigencies of military service require a denial of such request. Duration of stay. The tribunal may on its own motion and shall, upon application by the service member, which includes the required letters or communications to the tribunal demonstrating material effect, stay the action for a period not less than 90 days. A service member who is granted a stay of a civil action or proceeding may apply for an additional stay based on continuing material effect of military duty on the service member's ability to appear. The request for an additional stay may be made at the time of the initial application or any other time where the service member is unavailable to defend the action. The documents that the member must provide for an initial stay request must also be provided in the subsequent application. A letter or other communication from the member setting forth facts, stating how current military duty requirements materially affect the member's ability to appear and stating a date when the service member will be available to appear, and a letter or other communication from the service member's commanding officer, stating that the service member's current military duty prevents his or her appearance, and that military leave is not authorized for the service member at the time of the letter. Granting of the additional stay is within the discretion of the tribunal. Denial of additional stay request. There may be situations when the child support attorney may decide to oppose an additional stay and argue that military duty does not materially affect the member's ability to appear. Such situations may include the following. The location of the hearing is in close proximity to the member's base or post, and the member has a reasonable amount of annual leave accrued that can be used in trial preparation and attendance. The child support agency is willing to coordinate telephonic testimony or the member's participation via audiovisual means such Skype. Note that Section 316F of the Uniform Interstate Family Support Act UFSR requires tribunals to permit non-resident parties to testify by telephone, through audiovisual means, or by any other electronic means. If a tribunal, in its discretion, denies an additional stay, it must appoint counsel to represent the service member in the action or proceeding. The member may appeal the denial, but review is limited to determining whether the trial tribunal abused its discretion and arbitrarily denied the stay. The reviewing tribunal cannot simply substitute its own judgment. Default judgments. A default judgment is a judgment entered when a defendant fails to make an appearance at a proceeding after service of process. 50 U.S.C. 8931b provides that, prior to the entry of a default judgment in a case where the defendant does not make an appearance, the plaintiff must file an affidavit with the tribunal, setting forth facts to support either the statement that the defendant is in military service or the statement that the defendant is not in military service, or stating that the plaintiff is unable to determine whether the defendant is in military service. The affidavit may take any form as long as it is signed and certified, or declared to be true under penalty of perjury. As noted in the location discussion of this chapter, the Defense Manpower Data Center DMDC maintains a website that provides verification of whether an individual is in the military service. It is important to know that Section 389-31 applies to any civil action or proceeding in which the defendant does not make an appearance. If the agency files an affidavit showing that the defendant is not in the service, the tribunal can enter a default judgment. If the child support agency fails to file the required affidavit, the tribunal should not enter a default judgment. Unfortunately, in areas without a military population, child support agencies frequently do not include the required affidavit, and tribunals often improperly enter default judgments. If a default judgment is improperly entered, the judgment is voidable. That means a military member is entitled to later reopen the default judgment if certain conditions are met. However, until such time, the judgment is enforceable and entitled to full faith and credit. In order to avoid the possibility of the default judgment being reopened, it is important for the child support attorney to ensure the child support agency routinely files the required affidavits in all child support legal proceedings. When an affidavit indicates that the defendant is in military service, the tribunal may not enter a judgment until after the tribunal appoints an attorney to represent the member. If the appointed attorney is unable to locate the defendant, actions by this attorney are not binding on the service member and do not waive any of the service member's defenses. The filing of a false affidavit is a crime. Also, the failure to file an affidavit can subject an attorney to disciplinary action if it can be shown that the attorney had knowledge of the service member's military status. Evidence of knowledge includes previous letters to the service member's commander or other correspondence that clearly shows the attorney knew the status of the service member. Remember, a default judgment obtained in violation of the SCRA is voidable. That means it remains valid and binding until the service member takes affirmative steps to reopen the judgment. The SCRA permits a defendant to ask the tribunal to reopen its default judgment. 5 conditions must exist in order for a service member to reopen a default judgment. The tribunal must have entered the default judgment during the member's military service, or within 60 days after termination of or release from military service. The service member made no appearance. The service member or Hisher legal representative filed an application to reopen the judgment during military service, or no later than 90 days after the date of termination of or release from military service. The service member was materially affected by reason of Hisher military service in defending the action, and the service member has a meritorious or legal defense to the action, or some part of it. The SCRA makes it clear that an application for a stay does not constitute an appearance for jurisdictional purposes and does not constitute a waiver of any defenses. What would constitute an appearance? That is a factual question about which courts may differ. Where the member has filed a response, requested genetic testing, and/or filed a financial affidavit with the tribunal will likely rule that the member has made an appearance and will not consider his or her later failure to appear at the hearing a default under the SCRA. The tribunal may also consider a member's participation in a telephone hearing related to the matter to constitute an appearance. In deciding whether the military member has made an appearance, the tribunal will also look at actions by an attorney appointed by the tribunal to represent the defendant under 50 U.S.C. 38931b. Actions by an appointed counsel will not bind the member unless they are authorized by the member. Not only can an attorney's actions constitute an appearance by the member if they are authorized, but actions by a spouse or other individual pursuant to a power of attorney, either general or specific, may also constitute an appearance if similar action taken by an attorney would constitute an appearance. It is important to remember that the member's right to reopen a default judgment does not mean that the judgment will ultimately be reversed. Only upon a showing that all 5 threshold criteria have been met will the tribunal reopen a default judgment and consider whether to set it aside. Appointed counsel. Before a tribunal can enter a default judgment in a case where it appears that the defendant is in military service, the tribunal must appoint an attorney to represent the defendant. The SCRA provides little guidance with respect to the actual responsibilities of the court-appointed attorney. If the defendant is a service member, the appointed attorney is primarily responsible for attempting to locate the service member and obtaining a stay of the proceedings until the service member can be present. It is important to note that if the appointed attorney cannot locate the service member, the acts of the appointed attorney are not binding on the service member, and the attorney cannot waive any of the member's legal rights. A service member will be bound only to the acts of an appointed attorney that the service member has authorized. If the service member authorizes the appointed attorney to perform some act before the tribunal may construe those actions as an appearance by the member. Stay or vacation of execution of judgments and attachments under the SCRA. 50 U.S.C. App. 39-34 authorizes a tribunal to stay the execution of a judgment, attachment, or garnishment order entered against a service member. Additionally, the section authorizes a tribunal to vacate an attachment or garnishment against a service member's property. The stay provisions of this section are similar to those for a stay of proceedings under 50 U.S.C. 39-31 and 39-32. For a stay or vacation under 50 U.S.C. 39-34. 1. Military service must materially affect the ability of the military member to comply with the judgment, attachment, or garnishment action. And 2. The action or proceeding must have begun before or during military service, or within 90 days after military service terminates. A tribunal may grant the stay on its own motion if it finds material effect. However, the tribunal must grant the stay on the motion of the military member, unless it finds that military service has no material effect on his or her compliance with the judgment. If the member's military service existed and was considered at the time the tribunal initially entered the judgment, it is unlikely that a stay of judgment enforcement will be granted, assuming compliance with all of the requirements of the SCRA. A military member can use the stay provisions of 50 U.S.C. 39-34 to stop an enforcement action or to seek a downward modification of his or her child support obligation, where military service has caused a reduction in income. An example is a reservist who is called to active duty and experiences a reduction in income. In such a circumstance, a stay of enforcement of the original child support order may be appropriate. It is important to note, however, that 50 U.S.C. 39-34 does not permit retroactive modification of a support obligation. Tolling the statute of limitations. The legally required time limit in which an action or lawsuit must be filed is called a statute of limitations. Statutes of limitation differ depending on the type of legal claim. Statutes of limitation apply to actions filed in all tribunals, including federal court. Tolling means to suspend or hold in abeyance. 50 U.S.C. 39-36 provides for the tolling of statutes of limitation during the time that a person is in military service. The tolling applies regardless of whether the military member is a defendant or a plaintiff in the proceeding. The cause of action can have accrued either prior to or during military service. The one exception is that 50 U.S.C. 39-36 does not apply to federal internal revenue laws. The tolling provisions of 50 U.S.C. 39-36 are automatic once military service is shown. They are self-executing, which means no action is required by the service member. Unlike the stay provisions, there is no requirement for a service member to show that military service materially affected his or her ability to participate in the proceedings. The tolling of the statute of limitations is double-edged. It applies to service members automatically, whether they are the plaintiffs or defendants. Therefore, any issues concerning the statutes of limitations in a paternity or child support action will fall under the tolling provisions of 50 U.S.C. 39-36. Maximum rate of interest under the SCRA. 50 U.S.C. 337 of the SCRA limits a service member's obligations or liabilities incurred prior to entry into military service to an interest rate that is not to exceed 6% per year. The 6% interest cap is applicable during the time the service member is in military service. The 6% interest ceiling is available only if the debt or obligation was incurred prior to entry into military service, and the service member provides the creditor with written notice of military service and a copy of the military orders calling the service member to military service or extending service. The interest rate ceiling is not available for debts and obligations incurred while in military service. A creditor, such as a child support agency, may seek relief from the limitations of 50 U.S.C. 337 if, in the opinion of the court, the ability of the service member to pay interest in excess of the 6% ceiling is not materially affected by the service member's military service. Material effect is determined on a case-by-case basis. As a general rule, material effect is present if there is a reduction in income due to military service. This is more applicable to reservists in higher-paying civilian jobs. A reservist called to active duty may suffer a drop in income that could materially affect the service member's ability to meet an obligation. A child support attorney needs to be aware of 50 U.S.C. 337 because it can have an impact on interest that has been ordered on an obligation for unpaid child support if the obligation was incurred prior to the member's entry into military service. However, 50 U.S.C. 337 does not require the attorney to initiate anything. It is the service member's responsibility to contact the agency or tribunal and affirmatively invoke its provisions. Paternity establishment, military policy and regulations. In an action to establish paternity against a member of the military, the child support agency should always first try to directly contact the service member's alleged father. If the member does not respond, paternity establishment is probably the one area of family support where the child support attorney can expect the least amount of assistance from the military. This is not because the military views non-marital children as less deserving of support, but rather because, absent a legal paternity determination, there is simply little a military commander can officially do to assist the child support agency. Military regulations strictly limit the ability of a commander to become involved in civil matters. This is particularly true in civil matters like paternity establishment, where no order exists. In paternity establishment cases, a commander's roles are limited to informing a service member of the claim, informing the member of his legal and moral obligations, if any, referring the member to a military legal assistance attorney if the member has questions about his legal rights, urging the member to provide financial support to the child if, after legal consultation, the member admits paternity, and providing complete, accurate, and timely information to the person or agency bringing the paternity action. In cases where the member admits paternity to the commander and agrees to provide financial support, the commander will assist the member in obtaining the appropriate available housing allowance, understanding what he needs to do to complete a voluntary allotment for the child, obtaining a military identification card for the child, and obtaining leave, if requested, in order to marry the mother of the child. The military member may also be entitled to additional allowances for the support of the child, depending on the allowances to which the member is already entitled. In cases where the military member verbally admits paternity, but refuses to provide financial support, the role of the commander with respect to the subordinate is limited to referring that individual to a legal assistance attorney. In cases where the military member denies paternity, a commander cannot force a member to cooperate with a child support office in its efforts to establish paternity. However, military policy requires individual members to manage their personal affairs honorably and to comply with lawful orders. It may be helpful for the child support attorney to call upon this policy when appropriate. For example, when direct contact with the military member is unsuccessful, a child support attorney can request that the commander speak with the member to encourage the member to comply with an order for genetic testing. This request should be in writing and explain the consequences of a failure to appear for the testing. Although the military commander cannot force a subordinate to appear for genetic testing, a tribunal can use its contempt powers to enforce an order requiring the member to appear for genetic testing. Evidence relative to paternity establishment. If the service member does not acknowledge paternity, the leave and earnings statement less of a member in the Army, Air Force, Navy, or Marines may have information that nevertheless evidences a parental relationship. Field 51 of the LESS contains codes that identify the type of dependents, such as a spouse and/or child, that the member claims for basic allowance for housing BA purposes. If the member will not voluntarily produce their LESS, the child support attorney can serve the member with a request for production of documents. In addition, the attorney can ask the child support agency to administratively order genetic tests for the purpose of establishing the probability of paternity. Acknowledgement of paternity. Because they are federal facilities, military hospitals are not required to participate in the state in-hospital paternity acknowledgement program. However, many medical hospitals voluntarily participate in such programs. The child support attorney can play an important role in helping the hospital and the hospital's legal advisor understand the paternity acknowledgement program and the benefits not only to the child, but also to the parents. Benefits of paternity establishment. Paternity establishment provides the parents and the child with legal rights to Social Security benefits, life insurance benefits, and inheritance. By establishing paternity, the child has legal rights to other benefits as well, such as veterans' benefits and health care coverage. For example, in order for a child to be enrolled in TRICARE, a child must be the dependent of a military sponsor. If a child was not born during marriage, the child is not eligible for TRICARE benefits unless there is a legal determination of paternity. Support establishment. Military policy and regulations. Similar to its position in paternity cases, the military views the establishment of a child support order as a matter for the civilian courts. Where no support order exists in the case, there is little a commanding officer can do to compel a subordinate to participate in the order establishment process. It is important to note at the outset that all branches of the military maintain regulations that require service members to support their families. In the absence of a support order or an agreement between the parties on the support amount, the branches vary with regard to the amount of support that is considered adequate. Where the regulations specify a particular amount, it is generally less than the amount called for under most state child support guidelines. Accordingly, the best practice is to establish a support order in accordance with your state laws and procedures at the earliest opportunity. In broad statements of policy, all branches of the military prohibit their members from using their military duty to avoid providing financial support to their families. In support order establishment situations, each branch of the military provides additional policy and regulations defining the roles of service members and their commanding officers. For example, Army policy requires that soldiers provide adequate financial support to their family members to make certain that their financial needs and welfare do not become official matters of concern for the Army. In cases where the military member is not cooperating with the order establishment process and not providing financial support for his or dependents, it is appropriate for a child support attorney or caseworker to notify the member's commanding officer of the alleged financial non-support. In response to this notification, the commanding officer must meet with the member to determine the validity of the allegation. As part of the inquiry, the commanding officer may take steps to stop the member's receipt of any dependent-based pay, for example, basic allowance for housing that the member is not using to meet the needs of these dependents. The commanding officer may also advise the member to consult with a legal assistance attorney. After the commanding officer meets with the member to discuss the allegation of non-support, the commanding officer's responsibilities vary depending upon the service branch. The Army requires the officer to respond to the Child Support Office within a reasonable time. If the soldier consents to the commanding officer providing such detail, the commander's reply will include a statement as to whether the soldier admits they have an obligation to provide financial support to their family, and if not, why not. If the member admits they have failed to provide this financial support, the commander will detail the immediate steps the member will take to provide this financial support in the future. For example, the service member can establish a voluntary allotment. However, because it is a voluntary allotment, the member can terminate it at any point. Voluntary allotment of support. As noted, members of the military may establish a voluntary allotment of earnings and direct money from their pay to their dependents. In fact, military rules strongly encourage members who are separated from their families due to their military service to establish voluntary allotments to provide for the financial support of their dependent family members. Because it is voluntary, service members can generate this allotment even before a child support order exists in the case. A commanding officer will help a member obtain the voluntary allotment forms. Additionally, a military member can use MyPay to establish the allotment. Although a commander can order a subordinate to obtain a voluntary allotment for his or her family, if the member is not supporting them as required by regulation, a commander cannot actually issue the allotment. There are limited instances when this remedy may be useful in processing child support cases involving the military. In discussions with the member or the member's attorney in cases where no support order exists, it is appropriate to point out that a voluntary allotment can help avoid the accumulation of unpaid child support during the order establishment process. In addition, the member should understand that this procedure provides an official record of payments that will help the member get credit for payments made prior to the entry of the order in states that authorize retroactive support. However, from the perspective of the child support program, a voluntary allotment should be viewed as a temporary action until a support order can be established and an income withholding order sent to DFAS. Determining income of service member. For all states and for tribes participating in the Title Roman 4D program, the establishment of an appropriate support obligation relies upon a full disclosure of the member's income. In the military, a member's basic pay is frequently not a complete picture of that person's income. Military pay is comprised of basic pay, available allowances, for example, basic allowance for housing (BA), basic allowance for subsistence or separate rations (BAS) or SEP-RATS, special skill pay, for example, flight pay, and bonuses such as re-enlistment. For all branches of the military, this information is provided on the member's leave and earnings statement (LES). The LES is a comprehensive document that provides a wealth of information that is critical to the order establishment process. The LES has 78 separate fields that include, among other things, the following information: member's name and SSN fields 1-2. All pay the member receives base, special, incentive, and bonus field 19. All allowances and entitlements the member earns field 10. Members' leave balances fields 25-32. Type S of dependents the member claims field 51. Members' declared state of domicile field 44. The child support attorney must understand how to decipher the LES information in order to determine accurately a military member's complete income. For each service, DFAS has published a guide to understanding an active duty LES for that branch. Note that the LES reports various types of income for the current pay period and for year to date. The LES also identifies whether a given source of income is taxable. Review the LES carefully to determine the true net or disposable income available to the member. For example, BAS and BA are not taxable, so if the state guideline includes these allowances in income, they should not be reduced by taxes in order to reach net income, as other types of income may be. Similarly, pay in two situations serving in a combat zone and performing qualified hazardous duty is not taxable. Some allotments are voluntary, such as deductions for retirement accounts, and may not be appropriate reductions from gross earnings for the purpose of support guideline calculations. Also be aware that some special skills and hazardous duty pay may be for a limited time. An attorney should review at least 6 months of pay in order to get a complete financial picture. The child support attorney should also request the member's tax returns. Many service members supplement their basic pay with investment income or second jobs. As noted earlier, however, There is a portion of military pay, for example, BAS and BA, that is not taxable. Therefore, although tax records may include income not reported on the member's military pay stubs, the pay stubs will report income that does not appear on the member's tax return. It is important to review both documents to ensure an accurate picture of the member's income. Federal resources for obtaining military income information. Payroll data about active and reserve service members and National Guard members is provided to the FPLS through DOD's quarterly wage reporting to the National Directory of New Hires. OX then reports that information back to the states. In addition, caseworkers and attorneys may have access to income information through the OX Child Support Portal. As noted earlier, the portal is a secured internet application that provides direct access to FPLS data. One of the applications available through the portal is the DOD Entitlement Application. This application provides monthly base pay, bonuses, and entitlement pay information. Using the application reduces the need to submit a Freedom of Information Act FOIA request, a subpoena, or a request for production of documents. If a member refuses to provide the Child Support Office with a copy of a current and complete LES, determining income of veteran. The easiest way for a child support agency to learn about a veteran's benefits is from the FPLS and the Child Support Portal. A child support attorney can also use a subpoena to obtain such information if the subpoena follows the guidelines set forth in the Privacy Act. Inclusion of veterans' benefits in income of veteran. Veterans may receive a number of military benefits, including service-connected disability compensation, a VA pension, a needs-based benefit paid to wartime veterans who meet certain age or non-service connected disability requirements, and education and training benefits. Many child support guidelines do not expressly address veterans' benefits. When they do, it is usually in the definition of income. The child support attorney should be aware that although veterans' disability compensation benefits are exempt from garnishment, federal law does not prohibit the consideration of veterans' disability benefits in the establishment of a support obligation. The relevant case is Rose v. Rose. The Tennessee courts had found a veteran in contempt when his only means of complying with a support order was to use his veteran's benefits received as compensation for a service-connected disability. In upholding the Tennessee decision, the Supreme Court made several statements that are applicable to establishment proceedings. The court noted that in setting the non-custodial parent's financial responsibility for child support, the Tennessee trial court had considered, along with other factors identified by a Tennessee statute, the earning capacity, obligations and needs, and financial resources of each parent. The non-custodial parent's income was then, and still was at the time of the appeal, composed entirely of benefits received from the Veterans and Social Security Administrations. He received monthly $1 to $211 in Veterans Disability Benefits, $1 to $806 in Veterans Aid and Attendance Benefits, $90 in Veterans Dependents Benefits, and $281 in Social Security Disability Benefits. The children received an additional $94 a month in Social Security Children's Insurance Benefits. The Tennessee trial court had ordered the parent to pay $800 a month as child support, in addition to the Social Security Children's Insurance Benefits. When the non-custodial parent began paying only the $90 in Veterans Dependent Benefits, the custodial parent filed for contempt. The veteran responded that only the Department of Veterans Affairs, or the Social Security Administration, could require him to pay more in child support. In discussing the apportionment statute at 38 U.S.C. 5-107, now codified at 38 U.S.C. 5-307, the court stated, the parties cite no legislative history on the meaning of 3-107(2), and our search has uncovered nothing of a dispositive nature. Nowhere do the regulations specify that only the administrator may define the child support obligation of a disabled veteran in the first instance. To the contrary, appellant, joined by the United States as amicus curiae, concedes that a state court may consider disability benefits as part of the veteran's income in setting the amount of child support to be paid. Later, the court states, neither the Veterans Benefits provisions of Title 38 nor the garnishment provisions of the Child Support Enforcement Act of Title 42 indicate unequivocally that a veteran's disability benefits are provided solely for that veteran's support. Support enforcement. This section of the chapter identifies the various enforcement remedies and procedures specifically available in cases where the non-custodial parent active duty, reserves, civilian employee of DOD, retired service member, or National Guardsman activated to federal service receives wages or other income from the military. Federal regulations and the rules of each service branch require military members to honor the terms of their child support orders. These military rules give commanding officers the authority to punish members who fail to support their dependents. The federal statute and regulation that govern income withholding from federal employees are the ones governing garnishment processing for all military branches. 42 U.S.C. 659 and 5 CFR, Part 581. Each branch has also developed the following policy regarding support. The Army. Army Regulations 608-99, Chapter 2 Family Support, Child Custody and Parentage. The Air Force. Secretary of the Air Force Instruction, FE 36-2906, Personal Financial Responsibility. The Navy. U.S. Department of Navy, Navy Military Personnel Manual Milpersman Art. 19754 30 Support of Family Members Art. 58800 10 Paternity Complaints. The Marine Corps. U.S. Marine Corps, Order P58816 Vol. 9 Marine Corps Manual for Legal Administration, Legal Admin Dependent Support and Paternity. The Coast Guard. U.S. Coast Guard Commandant Instruction, Contenced M19602 Discipline and Conduct. Chapter 2E Support of Dependents. Voluntary Allotment of Support. As noted earlier, members of the military may establish a voluntary allotment of earnings and direct money from their pay to their dependents. While the child support attorney should be aware that a voluntary allotment is an option, it is not an enforcement tool that a child support attorney or caseworker can generate. Only military members can initiate a voluntary allotment. It is also important to understand that members can revise or terminate a voluntary allotment just as easily as they can start one. Therefore, when a child support order exists in a case, the child support attorney should not rely upon the voluntary allotment as the mechanism to divert child support from the member's earnings to his or her family. Involuntary withholding of military income for support. The main vehicle for involuntarily attaching military income for support is an order notice to withhold income for child support based on state law. The federal statutory military allotment is also available, but this provision in law predates immediate income withholding and is seldom used. Child support agencies will most often use their state child support withholding law via the approved income withholding order notice for support to attach military income. Military income subject to withholding. The following income of a military member or civilian DOD employee is subject to state income withholding to enforce a child support obligation. Military active duty pay, basic pay and certain bonuses, but not basic allowance for housing (BA) or basic allowance for subsistence (BASIPRT) rations. Military reserve and retired pay. Federal DOD civilian employee pay and civilian retirement pay. Any other remuneration for employment. Military Payment Processing Center. The Defense Finance and Accounting Service (DFAS) processes the pay for military members of the Army, Navy, Air Force, and Marines who are on active duty, in the reserves, and retired from the military. It also processes the pay for civilian DOD employees and members of the National Guard who have been activated into federal service. When initiating income withholding or the federal statutory military allotment, the Child Support Agency must send the appropriate form to the appropriate payroll processing center. All income withholding orders for active and reserve components and retired members of the Army, Navy, Air Force, and Marines, and all notices to initiate statutory military allotments for uniformed services on active duty should be sent to DFAS Garnishment Law Directorate, P.O. Box 998,002, Cleveland, 044 99 8002. or fax to 877-622-5E93088. Note: DFAS does not process payroll for civilian employees of government contractors working on a military project. The Coast Guard processes its own payroll for active duty, reserves, and retired members. For the Coast Guard, you will need to mail or fax the income withholding order to Commanding Officer LGL, Pay and Personnel Center, 444 SE, Quincy Street, Topeka, KS 60 16683 3D 591, or faxed to 785 339 2200. An involuntary income withholding for support, regardless of the specific form used to implement income withholding, has priority over a pre-existing voluntary allotment. State income withholding orders for child support. In most support enforcement cases involving a military member, the Child Support Agency should send the approved income withholding order notice for support to the appropriate payroll office listed above. Note that DFAS is able to receive electronic income withholding orders and send withheld earnings electronically EFT, and all state child support agencies are processing withholdings in that manner. As of January 2021, the Coast Guard is unable to receive income withholding orders electronically. However, it does send payments electronically to the state disbursement units as dues. Due to DFAS's payroll processing requirements, the cutoff date for implementing an income withholding order against an active duty member is the 7th of the month. This is true for both state income withholding and the federal statutory military allotment. The cutoff date is the 15th of the month for implementing an income withholding order against a military retiree. DFA's legal staff need up to 15 days to process a withholding request, so it sometimes takes up to 60 days before the SDU receives the initial payment. Note that DFAS does not send the military member a copy of the income withholding order notice. It is therefore incorrect for a child support agency to assume that DFAS, as the employer, is giving notice to the non-custodial parent of his rights and responsibilities. Also keep in mind that when the state child support withholding order ends, the child support agency must notify DFAS in order for the military withholding to cease. Income withholding when reservist or National Guard member is called to active duty. If a non-custodial parent is employed in the civilian sector and is called to active duty, any income withholding order that is in place against the parent's civilian income is not automatically transferred to DFAS. The Child Support Agency must send an income withholding order to the appropriate place, either DFAS Garnishment Law Directorate in Cleveland, Ohio, or the Coast Guard Pay and Personnel Center in Topeka, Kansas. Keep in mind that although civilian employers are required to forward money to the SDU within 7 business days from the date it is deducted, DFAS deducts the child support payments from a service member's paycheck twice per month, and generally sends those payments to the state child support agency once a month on the first business day of the month, following the month from which the payments were deducted. However, please note that there are times when DFAS will send a payment out during the month that it was deducted because the end-of-month payday falls on a weekend or holiday. It is good customer service to let the custodial parent know in advance that the parent will likely receive payments on a different schedule than when the non-custodial parent was paying support through withholding from his or her civilian pay. Income withholding when a military member retires. If a member goes from active duty to retirement, a new income withholding order is not required. However, because the active duty pay and the retired pay are on completely different pay systems, one of the parties should contact DFAS to inform them that the member has retired so DFAS can transfer the income withholding order from the member's active duty pay to his retired pay. Please note that once the member has retired, it can take 30 to 60 days for a child support payment to be issued, as the Retired and Annuitant Pay Directorate has to first create the retired pay account. DFAS cannot begin withholding support from retired pay until the retired pay account is established. This means there will be a delay in the initial payment. The Coast Guard will also automatically move a retiree's income withholding to his or her retired pay. Uniformed Services Former Spouses Protection Act (USPSA). This act is another avenue available to collect child support from retired military personnel. The USPA provides a method of enforcing current and/or previously owed arrears, child support, and current alimony if they are awarded in a court order. An income withholding order is not required. The spouse or former spouse can collect child support by submitting a certified copy of the court order that awards the child support arrearages, or alimony, along with an application for former spouse payments from retired pay, DD Form 2293. If seeking to collect child support arrearages, there must be a court order determining the total arrearages, and the order cannot be older than 2 years from the date the designated agent for the appropriate uniformed service receives it. Court orders must be certified by the clerk of the court that issued the order. The USPA limits withholding to 50% of disposable retired pay. However, when a USPA application, a certified copy of the order, and a certified support income withholding order are submitted, the withholding limit is raised to 65%. A limitation to this remedy is that it cannot be used to enforce a support obligation if the parties were not married. Note also that in almost all cases, it is the spouse or former spouse of the retired military member who directly initiates enforcement under USPA. The child support agency does not initiate it. Payments paid under the USPA are made once a month and are paid directly to the spouse or former spouse. A former spouse can collect current alimony under the USPA, but not alimony arrearages. Federal Military Allotment Statute. The federal statutory allotment is a separate and distinct income withholding remedy that is specifically directed toward the military. A child support agency can use it to enforce both child and spousal support obligations owed by a member of one of the uniformed services on active duty. The member must have arrears totaling at least 2 months' amount of support. The amount of the allotment is the amount necessary to comply with the support order. Because of these two limitations, 1, the allotment is not immediate, but requires 2 months' amount of arrears, and 2, it will only be for current support, unless the support order specifically sets an arrearage payback amount. DFAS reports that very few cases are submitted via the federal statutory allotment process. To initiate a federal statutory allotment, there must be a notice from an authorized person requesting the particular military branch to initiate the allotment. An authorized person is defined as a Title Roman IV agent or attorney, and a court with authority to issue a support order or an agent of the court. The notice can be as informal as a letter, but must include the military member's full name, the military member's SSN, a statement that the arrears are equal to or greater than the current child support owed for 2 months, a certified copy of the underlying child support order, the date the allotment should stop, and a statement that the person writing the notice is an authorized person. Exhibit 14.5 is a sample letter to request the federal statutory military allotment. Send this notice to the same payroll processing center that receives the approved income withholding order notice for support. Income withholding against veterans' benefits received from the Department of Veterans Affairs. Veterans' disability benefits are not subject to withholding unless the member has waived a portion of retired or retainer pay in order to receive such compensation. This situation occurs when a former armed service member waives part of his or her retired pay, which is taxable, in order to receive the disability compensation, which is non-taxable. That part of the veteran's payment that is in lieu of the waived retired pay is subject to garnishment. However, if the member's entitlement or disability compensation is greater than their entitlement to retired pay, and the service member waived all their retired pay in favor of disability compensation, then none of the disability compensation is subject to garnishment or attachment. DFAS does not process the garnishment of veteran disability compensation. In the limited circumstance when VA disability compensation is garnishable, because it is received in lieu of retirement income, send the income withholding order to the VA regional office serving the veteran. Apportionment of veterans' benefits. Availability of apportionment. In certain circumstances, part of a veteran's benefits may be apportioned. An apportionment reduces the amount of the benefit going to the veteran and instead routes the money to a different beneficiary. 38 U.S.C. 5307 and implementing regulations provide for an apportionment of all or any part of a veteran's pension, compensation, or emergency officer's retirement pay in the following two circumstances. If the veteran is incompetent and is being furnished hospital treatment, institutional, or domiciliary care by the United States or any of its political subdivisions. If the veteran is not living with his or her spouse, or if the veteran's children are not living with the veteran, and the veteran is not reasonably discharging his or her responsibility to support the spouse or children. The statute also provides for apportionment of certain benefits in certain circumstances when the veteran is deceased, and when the veteran is not living with his or her spouse, or if any of the veteran's children are not in his or her custody, and the veteran is receiving a subsistence allowance payable to the veteran under 38 U.S.C. Chapter 31 Training and Rehabilitation for Veterans with Service-Connected Disabilities or Educational Assistance Allowance payable on account of dependents under Chapter 34 Veterans Educational Assistance. The statutory provision most relevant to the child support attorney is the one authorizing an apportionment if the veteran is not residing with his or her spouse, or if the children are not residing with the veteran, and the veteran is not reasonably discharging his or her responsibility for the spouse's or children's support. As noted later, the VA will approve the apportionment only if it will not cause undue hardship for the veteran. The attorney should also be aware of special apportionments authorized under 38 CFR 3451. The regulation authorizes a special apportionment of a veteran's pension, compensation, emergency officer's retirement pay, or dependency and indemnity compensation, when a hardship is shown to exist for a veteran's dependents. The child support attorney cannot seek either apportionment solely in the name of the child support agency. The custodial parent must request them. However, it is important for the attorney to be aware of these provisions in order to inform the custodial parent of their availability and to assist the parent if needed. Receipt of an apportionment may also impact the child support guideline calculation. See the later discussion herein. Procedure for requesting an apportionment. Implementing regulations are at 38 CFR 3453-458. When the custodial parent applies for an apportionment, the Department of Veterans Affairs VA will ask the custodial parent to complete VA Form 210788. Information regarding apportionment of beneficiaries' reward. Among the information that the parent must provide are the following: name of person S for whom an apportionment is sought and their relationship to the veteran. Amount of support the veteran is contributing to the named person S. The frequency of these contributions. The form also asks whether the veteran's children have been adopted by another person. If that is the case, the VA will not allow an apportionment. Part I of the form then asks the requesting party to provide income and net worth. If the requesting party is claiming an apportionment as the custodian of the veteran's child REN, the form directs the party to report his or her income and net worth, and that of the child REN. Part II of the form solicits information about monthly living expenses. Pursuant to guidance from OX, it is appropriate for the child support agency to write to the VA, using agency letterhead, to request an apportionment review 100. The letter should be signed by both the appropriate child support agency official and the custodial parent. The agency should address the letter to the VA regional office, servicing that veteran's benefits. The VA offers a toll-free number to determine which regional VA office is appropriate: 1-800-827-1000. Review by the VA. The apportionment process is administrative. The VA will conduct an initial review of the application for apportionment, VA Form 210788, to determine if one of the following three exceptions applies. The amount of the veteran's benefits is too small to be divided between the veteran and his or her children. Another person has legally adopted the veteran's children, 101, or the beneficiary who is receiving the veteran's benefits is the one who is requesting the apportionment, i.e., the veteran cannot ask the VA to send part of his or her check to the children. If one of these exceptions is present, the VA will not allow an apportionment. In the absence of an exception, the VA will gather evidence related to two main questions. First, do the children need financial assistance per 38 CFR 3451, or do they live apart from the veteran and not receive a reasonable level of support, as stated in 38 CFR 3450? Its review will be based on information that the custodial parent has provided. Second, would taking money from the veteran's benefits cause the veteran financial hardship? To answer that question, the VA will ask the veteran to also complete the form detailing income, net worth, and monthly living expenses. The VA will allow the veteran to give a written statement explaining the support that the veteran has provided his or her children, and why an apportionment would cause the veteran great financial hardship. Keep in mind that the VA's primary obligation is to the veteran. Even if the claimant demonstrates a need, the VA cannot impose undue hardship on the veteran. Based on its review, the VA will render a decision. In two circumstances, it will deny an apportionment. The person seeking the apportionment for child support has not shown that the children have a financial hardship. Even if the person seeking the apportionment for child support has shown financial hardship, the veteran has shown that he or she will also suffer financial hardship from the loss of the money. The special apportionment under 38 CFR 3451 refers to undue hardship. If, on the other hand, the VA finds that the person seeking the apportionment for child support has shown financial hardship, and the veteran has not shown that he or she will suffer financial hardship, the VA will grant the apportionment. The veteran has a right to appeal the decision. Amount of apportionment. The decision to grant an apportionment is discretionary with the VA, as is the amount of any apportionment. It is not subject to trial court review, nor does it need to be based on any child support order. Pursuant to federal regulations governing special apportionments, the amount apportioned should generally be consistent with the total number of dependents involved. Ordinarily, apportionment of more than 50% of the veteran's benefits would constitute undue hardship on him or her, while apportionment of less than 20% of his or her benefits would not provide a reasonable amount for any apportionee. Incarcerated veterans. When a veteran who is receiving disability compensation is incarcerated for more than 60 days for a felony conviction, the veteran will receive a reduced amount of compensation, beginning on the 61st day of incarceration. If the veteran has a service-connected disability rated at 20% or more, the veteran will not receive such compensation that exceeds the rate of compensation under 38 U.S.C. 114A. If the veteran has a service-connected disability rated at less than 20%, the veteran will not receive such compensation that exceeds 1/2 of the rate of the compensation under 38 U.S.C. 114A. All or any part of the compensation not paid to the incarcerated veteran may, as appropriate in an individual case, be apportioned as provided by 38 U.S.C. 5E307. Pursuant to federal regulations, the VA will inform the veteran whose benefits are subject to this reduction of the rights of his or her dependents to an apportionment while the person is incarcerated, and the conditions upon which payments to the veteran may be resumed upon his or her release from incarceration. In addition, the VA will notify the veteran's dependents of their right to an apportionment if the VA knows of their existence and can obtain their addresses. The VA may grant an apportionment to the veteran's spouse, child (REN), and dependent parent of all or part of the compensation not paid to the incarcerated veteran. The VA will base its decision on individual need, factoring such things as the apportionee claimant's income and living expenses, the amount of compensation available to be apportioned, the needs and living expenses of other apportionee claimants, as well as any special needs of all apportionee claimants. Effective apportionment on child support guideline calculation. Very few states expressly address apportioned veterans' benefits within their child support guidelines. One state that does is Oregon. Its child support guidelines define apportioned veterans' benefits as the amount the U.S. Department of Veterans Affairs deducts from an obligated parent's veterans' benefits and disperses to the child or to the child's representative payee. Pursuant to the guidelines, The benefits paid to the child based on the parent's disability is included in that parent's income, regardless of whether that parent is expected to pay or receive support. If the veteran becomes the obligated parent, the tribunal may then reduce the resulting cash child support obligation dollar for dollar in consideration of any apportioned veteran's benefits. The reduction is discretionary, not mandatory. Medical support. A legal dependent of an active or retired military member is eligible for services through the military health system. This is true regardless of whether the dependent resides with a member. TRICARE is the health care program serving all uniformed services, including the Coast Guard, retirees, and their families. It is also available to National Guard and reservist members who have been called to federal active duty for more than 30 days and to their families. It is not available to civilian employees of DOD. To be eligible for care at military medical facilities or receive services through TRICARE, the child must be registered in the Defense Enrollment Eligibility Reporting System DEERS. The DEERS database maintains information on the military member, known as the sponsor, and the sponsor's dependents. It is used to confirm eligibility for military benefits, including health care. A sponsor is automatically registered in DEERS, but it is the sponsor's responsibility to enroll family members. Dependent children who are born during marriage, adopted, stepchildren, or non-marital children of record of a female member are entitled to DEERS enrollment and TRICARE benefit eligibility. Children born to unmarried parents, where the father is the military member, are also entitled to military health care and enrollment in DEERS if there is a legal determination of paternity. According to DOD 2020 eligibility requirements, the following constitute a legal determination of paternity for purposes of DEERS enrollment: a court order establishing paternity, a consent order of paternity that establishes paternity, a military staff judge, advocate judge, advocate general JAG legal opinion that establishes paternity, or a certified copy of a voluntary paternity acknowledgement. The voluntary acknowledgement form must be recognized by relevant and applicable state law as establishing legal paternity. That means both parents must sign the voluntary form, with their signatures authenticated by a notary or witness ease, depending on state law. The parents do not have to sign at the same time. Because each state has its own acknowledgement form, the parents must use the form from the state where the child was born. The easiest way to enroll a dependent in DEERS is for the military member sponsor to enroll the child. There is no need for legal involvement. The military member can go to a nearby Uniformed Services ID card issuance site. This is also referred to as a RAPIDS ID card office or facility. RAPIDS is the acronym for the Real-Time Automated Personnel Identification Card System. The member can also enroll the child during pre-deployment processing programs. In the case of a child born during marriage to a male military member, the member can establish dependency by bringing a certified copy of the child's birth certificate, a certificate of live birth, or an FS-240, consular report of birth abroad. If the child was not born during marriage, the male military member also needs to bring documentation see list above, establishing a legal determination of paternity. Complete instructions, including a pre-arrival checklist, are available online. The military sponsor must complete DD Form 172-2, Application for Identification Cardier's Enrollment Form. A verifying official at the site must validate the documents establishing dependency. Once that is done, the official will register the child, which will automatically result in TRICARE enrollment. If the military member does not enroll the child in DEERS, the custodial parent can also enroll the child by going to a Uniformed Services ID card issuance site and presenting the appropriate documents to the official who verifies dependent status. The parent or child support agency can use the internet to locate the nearest facility. The custodial parent will need to present the same documents that the sponsor would have presented. Note that genetic test results are not considered adequate documentation of paternity. If this is a case where the sponsor will not sign the enrollment paperwork, the verifying official can sign on the sponsor's behalf, provided all of the required documents are present. The official will document the failed efforts to obtain the sponsor's signature. The sponsor may not decline coverage of his or her dependent child. If the sponsor is active duty, registration of the child in DEERS automatically results in TRICARE enrollment. DEERS will enroll the child in either TRICARE Prime or TRICARE Select, depending on the child's address in DEERS. If the sponsor or custodial parent wishes to change between TRICARE Prime or Select, there is a limited time period to make that change. Otherwise, they may change coverage during the TRICARE open enrollment season each fall. OX considers TRICARE to meet its definition of health care coverage. However, it is not appropriate to send the National Medical Support Notice NMSN to the Defense Management Data Center DMDC to enforce health care coverage for dependents of active duty military or retired military personnel. If the Child Support Agency determines a child is eligible for enrollment, as indicated by the DMDC FCR match, or by the FAIN from the New Hire Report, or the Quarterly Wage Report, the agency should ask the custodial parent to either verify enrollment or contact a nearby Uniformed Services ID card issuance site with the proper documentation to initiate enrollment of the dependent in DEERS and TRICARE. For DOD civilian employees, child support agencies must continue to send the NMSN to the appropriate DOD Human Resource Office. The address for the appropriate HR office is included as part of the new hire and quarterly wage response that is sent as an FPLS match. Access, parenting time, and custody issues. Although child support agencies continue to focus on core services, they also provide services or work collaboratively with other programs to engage non-custodial parents in the lives of their children, increase non-custodial parent employment, improve family relationships and encourage health marriages, secure health care coverage, and help prevent family violence. One area in which child support agencies are increasingly involved is co-parenting, including parenting time visitation. States receive $10 million per year in federal funding for the Access and Visitation Program, administered by OX. This program supports and facilitates non-custodial parents' access to and parenting time with their children. Services funded by this grant program include mediation, counseling, education, development of parenting plans, supervised visitation, safe exchange services, and development of guidelines for parenting time and alternative custody arrangements. Services vary among the states, although program services are not limited to parents in the child support program. An increasing number of states are prioritizing services for families with child support cases. In some states, the Child Support Agency participates in the coordination of services along with other agencies. In some states, the Child Support Agency also plays a significant role in ensuring voluntary, agreed-upon parenting time plans are included in child support orders. Chapter 15 discusses the relationship between child support, custody, and parenting time arrangements in depth. This chapter discusses state laws, military regulations, and family resources related to parenting time and custody that specifically impact service members. State laws. State laws govern the relationship between individual parents, such as marriage, divorce, separation agreements, parenting time plans, and custody. These laws vary. With regard to custody, some states leave custody totally within the court's discretion based on the best interest of the child. Some states have a presumption of joint physical custody when the parents are in agreement. A few states purport to have a presumption of joint custody in all cases, which can be rebutted based on evidence of the child's best interest. Court rules may also establish requirements related to determination or mediation of parenting time and custody issues. In 2012, the Commissioners on Uniform State Laws approved a Uniform Deployed Parents Custody and Visitation Act to address custody and visitation parenting time issues that arise when parents are deployed in military or other national service. As of January 2021, 14 states have enacted it. Other states also have statutory provisions that address custody and parenting time in relation to deployed service members. Military regulations and policy. Where there is a court order, each service branch's military policy requires compliance with the order. The contents of a court order may be the basis for a lawful order from the member's commander. In the absence of a court order regarding visitation, parenting time, or custody, the service member must comply with the policy of their service branch. For example, the Army has regulations that address visitation and custody, including a commanding officer's duties if there is an inquiry regarding a member's failure to return a child. Resolution of parenting time issues. Sometimes parents need assistance in resolving parenting time issues. Some states have used federal access and visitation grant money to fund mediation projects through the court, the Child Support Agency, or other community organizations. Local jurisdictions often fund dispute resolution or mediation services through the courts. The service member has a number of additional resources available to assist with parenting time issues. Some are free, such as those offered through military legal assistance offices, military lay advisors and counselors, and non-military advocacy groups. These resources often provide counseling and mediation assistance. There are also resources targeted to the service member that are accessible through the Internet. Military legal assistance officers, who are often not licensed to practice law in the jurisdiction where their installation is located, do not represent service members in state court. The service member may hire a private lawyer to help resolve parenting time and custody issues, and to represent the member in any legal proceeding, custody proceedings, and the Service Members Civil Relief Act. As noted earlier, the Service Members Civil Relief Act (SCRA) provides for an automatic stay of civil, administrative, and judicial matters for at least 90 days upon a proper request from the service member. If a member receives notice that a proceeding related to custody or parenting time has been initiated against him or her during a period of military service or within 90 days thereafter, the member has the right under the SCRA to request that the action or proceeding be stayed for a period of at least 90 days. Remember that protection under the SCRA is not automatic. The member must produce a statement showing how his or her military duties materially affect the member's ability to appear and specifying a date when the member will be available to appear. The request must include a statement from the commanding officer stating that the member's current military duty prevents his or her appearance, and that military leave is not authorized for the member at the time of the statement. The initial request for a stay must be granted upon production of the required statements. The member also has the right to request that the court extend such a stay if necessary. The granting of an additional stay beyond the mandatory 90-day period is within the discretion of the court. If the member's request for an extension of a stay is denied, then the court must appoint an attorney to represent the member in the action or proceeding. Depending on the issues in the custody or parenting time proceeding, the service member may wish to proceed with the hearing rather than delay it. For example, a member who needs an adjustment to parenting time may decide to request electronic or telephonic testimony rather than allow a delay to affect the situation of the child. It is important for a service member to seek legal advice about invoking the protections of the SCRA as soon as possible after learning of a legal action. Service members may contact the nearest Armed Forces Legal Assistance Program office. The member may also seek assistance from a private attorney. Family Care Plan. A family care plan is a blueprint that spells out how the military member's family will be cared for in the member's absence, whether the member is deployed, on temporary duty, or otherwise unavailable because of military obligations. It allows for a smooth transition of responsibilities to a spouse or other caregiver when a service member must leave for short or long periods of time. These plans demonstrate to the commander that unit members will be ready to accomplish the mission of the unit with little or no disruption by family issues. However, as discussed later, it does not supersede a court order regarding parenting time or responsibility for making legal decisions affecting a child. Often service members mistakenly believe the contrary, who must have a family care plan. According to Department of Defense Instruction 183-4219, the following members within all active and reserve components and the DoD civilian expeditionary workforce are required to have a family care plan. Single parents with custody of children under 19 years of age. Dual military couples with custody of children under 19 years of age. They are required to develop a single family care plan that both members sign. Married service members who have custody or joint custody of a child, whose non-custodial biological or adoptive parent is not the current spouse of the service member. Service members who are solely responsible for the care of children under the age of 19 or adult family members unable to care for themselves in the service member's absence. This category includes situations where a service member's spouse is injured, chronically sick, or otherwise unable to care for family members or other dependents. Service members who, for any other reason, are primarily responsible for dependent family members. This category includes service members with spouses who speak little or no English, or are unable to drive or otherwise gain access to basic resources such as medical care and food. Service members who do not fit into any of these categories may also want to develop a family care plan. Each service has a corresponding directive that explains that branch's guidelines. Commanders and supervisors can tell military members about the resources available to help them create plans that meet their service's specific requirements. These resources include installation family support centers and legal assistance offices. When should a member make a family care plan? Service members should notify their supervisor or commander about creating a family care plan as soon as they enter any of the required categories above. Active duty members have up to 60 days to submit the final plan. Reserve component service members must submit their final plan within 90 days of alert notification. It is important that the member updates the family care plan when there is a change in family circumstances that result in the members becoming responsible for the logistical, medical, or financial support of another person. This is especially true when the court issues a child support, parenting time, or custody order. At a minimum, the member must provide written certification annually to his or her commander that the family care plan is current. What must be in a family care plan? The requirements for a family care plan may vary somewhat depending on the service branch or the member's particular circumstances. However, all plans must contain the following basic information: name and contact information of the member's caregiver and alternate caregiver. The caregivers selected must be non-military, at least 21 years of age, and capable of caring for themselves and the member's family. The member will be required to sign a statement certifying that the caregiver has accepted responsibility for the care of the member's family members, and that the member has provided the caregiver with necessary information and copies of all documents required to be included in the family care plan, such as powers of attorney. Note: the existence of a custody order will affect who is designated as caregiver. See discussion below. Provisions for short and long-term absences. Financial arrangements that ensure the self-sufficiency and financial security of the member's family. The member must provide documentation of allotments and other financial resources and describe how they will be used. A copy of the member's powers of attorney must be included with the plan. Note: the existence of a child support order will affect this information. Logistical arrangements for transporting family members and/or caregivers to a new location. If the member has different caregivers for short and long-term absences, the member's plan should address transporting family members from a short-term caregiver to a long-term caregiver in the case of deployment or other lengthy separation with little or no notice. The name of any non-custodial biological or adoptive parent not named as the caregiver, along with that parent's consent to the family care plan. Note: if the parent will not consent to the third-party caregiver, the member must explain the absence of such consent in writing and acknowledge the availability of legal counsel to discuss the associated risks and the best possible course of action, including the possibility of incorporating the family care plan into a temporary order by a court of competent jurisdiction. The name of the person the member designates to have temporary responsibility for the member's dependent family members in the event of the member's incapacity or death. If the member has named someone in his or her will to have custody of his or her children in the event of death, The family care plan should still designate someone to be responsible until permanent custody can be legally established. It may or may not be the same person as the caregiver. What are additional issues to address? The family care plan may also include specific instructions on arrangements for child care, school, medical care, and family activities. It may include the locations of important documents, such as wills, insurance papers, and birth certificates. It may also contain arrangements for communication between the member and his or her children during times of short and long-term separation. Relationship between family care plan and custody order. Although a family care plan is a very useful tool for addressing parenting issues, it does not take the place of a court order related to custody or parenting time. Therefore, despite the presence of a family care plan, either parent may seek a court order concerning parenting time or custody. Parents sometimes discover issues while they are preparing the family care plan that might cause them to seek modification of an existing child support or child custody order. If there is a conflict between the family care plan and the court order, the order prevails. On the other hand, the presence of a court order does not mean that a family care plan is unnecessary. Members who fall within the required categories of individuals under DOD Instruction 1D3-4219 must prepare a family care plan. They should ensure that the family care plan is consistent with the court order and may wish to incorporate certain provisions of the court order into the family care plan. Even members who are not required to prepare a family care plan may find it beneficial to do so. A family care plan or a non-military parenting plan can address the day-to-day parenting issues that most court orders do not address. For example, co-parenting couples may find it helpful to develop a plan for handling everyday children issues like extracurricular activities, religious instruction, discipline, tattoos, and piercings. In addition to military resources, members may wish to contact their local courts for information on child access, parenting plans, and mediation services. Conclusion: the Child Support Program touches the lives of many military and veteran families. Child support attorneys play an important role, not only in ensuring that children can count on reliable support from their military parents, but also in assisting their child support programs to provide supportive services to military families and veterans.